I should, just for completeness, refer your lordships to there's an act called the Housing and Planning Act 2016, which has a mechanism called rent repayment orders. These are referred to in the Renters' Rights Act as well. This is where a landlord has committed an offence under various sections cited in that act, and the tenant, or indeed the local authority, can go to the tribunal and seek a repayment of the rent that ought not to have been paid. Again, I think it's right to say, my learned friend will correct me if I'm wrong, I think it's right to say that doesn't only apply to assured tenancies, so it may not be of any relevance to the court, but just for the sake of completeness, in the sense that it applies primarily to assured or assured shorthold tenancies. It'd be very difficult to see how the rent could be repaid in the context of this case. At paragraph 26 of my appeal skeleton arguments, I've set out, probably starting from 26b on page 12, I've referred to numerous sections of the Housing Act that refer to rent paid or payable. Again, in the context of the extracts from Bennion, to which I referred the court earlier, bearing in mind the primacy of the language that the legislature has used, paid and payable, the normal grammatical meaning of those words suggests that there has to be a peculiar value. I've cited in footnote 6 various sections of the Housing Act which use that terminology, including section 22, and I've included those in the Joint Authorities bundle if your lordships and your ladyship wish to have reference to it. At 26c, again, a similar point, numerous sections refer references to the amount of the rent, again, means that there has to be a value ascribed to the rent. And then at D, I've referred to the rent arrears grounds. I just want to expand on that slightly. And there are 2 points to make, I think. The first, my lord, you asked my learned friend about effectively the different mechanisms for obtaining possession from tenants under section 21 and so on and so forth. So if a tenant is not protected under the Rent Act or the Housing Act, and they're exempt from the Protection from Eviction Act, then they can be simply kicked out, essentially. That would be the position of a lodger. There's no need for a notice to quit, which is the most basic mechanism for obtaining possession. We say that this tenant, in this case, is protected under the Protection from Eviction Act because her tenancy is granted for money's worth, but she doesn't come under classes that get additional protection. Hence, my client or my clients sought to terminate this tenancy by notice to quit and brought possession proceedings based on that. So occupants who get protection under the Protection from Eviction Act, but not the Rent Act or the Housing Act, they get the protection from summary eviction. So there have to be possession proceedings brought in. There has to be notice given, there have to be possession proceedings in the court, and they have to be evicted that way. Assured shorthold tenants, there are 2 mechanisms for obtaining possession, as my own friend said. There's under section 7 of the Act, you can serve a notice pursuant to section 8, relying on 1 or more grounds of Schedule 2. The first part of Schedule 2 are mandatory grounds. That includes ground 8, which is the mandatory rent arrears ground. The existence of ground 8 is a difference in the Housing Act 1988 compared to the Rent Act. In the Rent Act, there was no mandatory rent arrears ground. In the Housing Act 1988, there is a mandatory ground. That goes to the statutory context of deregulating and making these tenancies a more attractive proposition for landlords. The point being, there's a recognition of a threshold, and in most tenancies it's either 8 weeks or 2 months, broadly equivalent, arrears of rent existing at the date of service of the notice and at the date of the hearing for possession. As my own friend said, absent some sort of defence or counterclaim. If that's the accepted position by the court, then the court has to grant possession. So in my submission, that actually favours my interpretation, because there's a recognition of a seriousness of rent arrears that entitles the landlord to a mandatory possession order. In this case, as I understand it, my learned friend's position is there needs to be some sort of quantification or assessment mechanism carried out in order for the court to determine, one, whether or not this tenant actually has a assured shorthold tenancy at all, rather than falling into the exemption in paragraph 3 of Schedule 1. But also, the court would then have to determine the level of the rent arrears. My lord, you asked my learned friend about this. It presents various difficulties on a practical level. These possession claims are usually listed for 10 minutes. If the evidence to show the level of rent arrears is very simple. If the tenant says the landlord hasn't credited a payment they've made, they can simply show evidence of it by way of a bank statement or something of that nature. In this case, one can imagine all sorts of arguments about what work has been performed. Is the landlord supposed to have visibility or police what work the tenant is actually doing?
Well, they're listed for 10 minutes if they're
correct.
They're simple.
Yes,
if there's any complexity, they get adjourned off.
Yes, of course. But the point is, where the only matter in dispute is the level of rent arrears, evidentially that's a very simple matter for the court. If the court, as I think my learned friend is saying, in any of these cases would have to be undertaking a complex assessment mechanism, it simply goes to the point that, in my submission, it can't be what Parliament intended. And further to that, my lord, you made the point, well, effectively, what does it matter? Normally in these cases where there's a rent arrears claim, there's a money claim brought alongside, which is a very simple debt claim. You're just saying, this is the amount of rent under the agreement that hasn't been paid. It's a simple debt claim. In this case, as my own friend would have it, it would be a claim for damages to be assessed, which would involve quantum hearings and so on. It simply would introduce a level of complexity that, in my submission, the legislature cannot have intended when it enacted the provisions of the Housing Act 1988.
Yes, well, you mentioned Section 28. The other route is Section 21.
Yes. So, thank you, my lord. I just wanted to clarify on that. As I understood it, you said sort of very early on in the hearing, what does it matter if the landlord can just get possession pursuant to a Section 21 notice? The point on that really is just Section 21, by virtue of various acts or pieces of secondary legislation that have been enacted since 1988. I'm sure my learned friend will correct me if he disagrees on this, but Section 21 orders have become a lot more difficult for landlords to obtain. They have to have ticked a great many boxes in order to obtain a Section 21 notice.
They're done in large numbers up and down the country. It's box work for district judges.
It can be, but they're often defended on the basis of some sort of defect in the various statutory requirements. I can go through that, and I'm not sure. I'm not sure to what extent it actually assists the court in any event. I just wanted to address you on it as you'd raised it with my learned friend.
Well, I think my Mr. Colville was hinting at any rate that there may be some problem for you in serving a Section 21 notice. Perhaps that's not directly relevant to the appeal, but if that were the case, it would perhaps explain why we're here in the Court of Appeal months or years after the event, rather than taking the Section 21 route.
Well, there may be. Yeah, I wouldn't wish to speculate, and I'm not sure it is germane to the court's determination of this issue in any event. But in my submission, I think the point is the availability of a Section 21 order isn't determinative of the question of, or even relevant to the question of whether rent and rent being payable under the language of the statute should import the concept of services performed.
Well, it may not be, but I would struggle with the idea that Section 21, as a rule, creates enormous difficulties for landlords, because it's precisely because it doesn't that the present government, and indeed the previous government, decided to abolish it.
No, I take the point, my lord. I mean, I understand. You asked, incidentally, my lordships, I think you possibly both asked about the Renters' Right Act. I have looked up various provisions. I'm not sure that your determination today is going to be have far-reaching consequences in terms of the Renters' Rights Act, but I can address you if you wish on what may be the relevant provisions. I noted that ground 8 is being amended. The amount of arrears is increasing, but I'm not sure that particularly matters. It appears that the exemption in Schedule 1, so this paragraph 3, remains in place. There's also a new exemption for long tenancies, but that exemption seems to remain in place. The procedure for increases of rent in Section 13, which I've referred you to, that's changing. But again, I'm not sure that your determination is particularly going to affect that. Yes, having a quick look at it, it didn't appear to me that your determination is going to, certainly not in terms of what I've called the threshold or the gateway for protection under the Act. But my learned friend may wish to address you on that. There was some discussion of the quantification of the rent, and effectively the mechanism for that. In Barnes and Barrett, you've already looked at that. So Lord Justice Sachs, in that case, so it's page 70 of the Joint Authorities Bundle.
Yes.
I'd just point out at B, Lord Justice Sachs noted this practical workability point regarding the irrecoverable parts of the services in this sort of case. And I say that logic carries through. He says it suffices to say the good sense of the decision in Hornsby and Maynard is patent, it was correctly decided. Heading down to the bottom, I think your lordships and your ladyship had noted this. So at 8, or the paragraph beginning just under G, Lord Justice Sachs there says, at no time was there any agreed monetary quantification of the rent, nor was there any agreed method of quantification, nor was there any statute which provided a substitute for an agreed method of quantification. The court raised the possibility of the national wage being used as a method of quantification for the purposes of the gateway. The simple point, I recognise the attraction of that for the court as a matter of simplicity. The point I would make, just according to my research, the national minimum wage was introduced in April 1999, when the National Minimum Wage Act 1998 came into force. So I'll just make the simple point, that can't have been in the contemplation of Parliament in 1988 when they were enacting the Housing Act, that there could possibly have been a mechanism such as that could be used to quantify the value of rent or the value of services where the parties had chosen not to. And I would just make the point, having a predetermined quantification of the rents and the services does matter for various reasons. The Tenant Fees Act, which I referred to in my skeleton argument at paragraph 27, there's a cap now on the amount of deposit of 5 weeks' rent. So if the landlord took a deposit and the rent was subsequently determined, to be at a level where the deposit exceeded the 5-week cap, that creates some problems for the landlord, which in my submission is, it's difficult to see the fairness in that, where the parties haven't chosen
yes,
to.
and you just made the point that this is that's a provision that postdates the introduction of this legislation.
It is. I'm making a slightly different. No, I was attempting to make a slightly different point. Yes, I agree. There's probably limited utility in the court for the court in looking at an act in 2019 to see what Parliament intended in 1988. I fully accept that. The point I was making really is just rather than there being a single codifying piece of legislation which deals with all the other points that affect assured shorthold tenancies, there are various other acts that have been enacted since, but there's never been any clarification by Parliament since 1988 that rent in the Housing Act is supposed to mean anything other than its grammatical meaning or the meaning that had been ascribed to it in the Rent Act's decisions. The point I was trying to make, my lady, was just in response to, I think, a question that my lord asked my own friend earlier. What does it really matter about the quantification of the rent? I'm just making the point that if the landlord takes a deposit without the value of the rent having been predetermined, and the court or tribunal subsequently assesses that the value of the services to be higher than that, it could put the landlord in difficulty. It was just a point that goes to why there needs to be a value of the rent at the time the tenancy is entered into.
Well, I suppose you can make the point that the Tenant Fees Act assumes that under the existing law, rent means money, because otherwise we can't talk about an amount of 5 weeks' rent or whatever it is.
Yes, that's my lord. That's a more eloquent way of how I was trying to put the first point, which is looking at as the sort of statutory scheme, including the Tenant Fees Act. It all seems to have proceeded on the basis of Parliament can be assumed or inferred to have always understood rent as meaning payment of money, and there's certainly never been any clarification by Parliament or amendment of anything to suggest otherwise. I've just made a point so Lord Justice Sachs referred to any statute which provided a substitute for an agreed method of quantification. I would just make the point that Lord Justice Cross, his judgments at page 72, probably just worth the court noting that he doesn't extend it in the same way. So Hornsby and Maynard, effectively they say it needs to be payment of money. Montague and the Montague and Browning case in 1954, they say where it's services but they've been quantified by agreement by the parties, then that's okay. Lord Justice Sachs seems to extend it one stage further and say, well, it's okay as long as there's a method of quantification. My submission there would be it's undesirable to extend it that far, and certainly Lord Justice Cross and Lord Justice Russell don't seem to take it that far. Sorry, I beg your pardon. I think it was actually Lord Justice Russell's judgment on page 73 that I was thinking of. He says, as a matter of law, that whereas here you have a case in which there has been no attempt to assess or evaluate either the services to be rendered or the rental worth of the premises, the case is established. I would encourage the court, if the court is going to go with the Rent Act's meaning, to adopt that meaning rather than the extended interpretation that Lord Justice Sachs gives of saying you can do it by an appropriate statutory mechanism, where where that, it appears, wasn't in the contemplation of Parliament in 1988, nor in the contemplation of the parties here.
Yes.
Can I assist on anything?
Anything else? No, no. Thank you very much indeed.
Thank you.
Yes, Mr. Colville.
Griffin, my lord, I've just got five quick points.
Thank you.
My lord, firstly, on the point that my learned friend has just made, as he pointed out, Lord Justice Sachs envisaged that at the bottom of page 70, that where there's an agreement, agreed monetary quantification of the rent, then that would be covered. In terms of rent payable or to be paid, but where those words are used in the statute, it's quite clear that rent can be quantified, and in the absence of agreement between the parties, the court can reach an agreement. And as we can see from the transcript, both of the judgment and during the course of the hearing, the District Judge Chambers accepted that there was a value and it could be ascertained, but he rejected the fact that it was rent because there was no agreement on the money. There was in terms of the actual tenancy agreement itself. So given that it is quantifiable by the court, in my submission, it's not a step too far to find that in line with common law, the court can ascertain what the level of the rent is, where rent is paid in money's worth, in order to then follow through to determine is the tenancy an assured shorthold tenancy under the 88 Act, and are the right tenants' rights protected. My lord referred to box work up and down the country in terms of relying upon Section 21 notices, and it's right. If the landlord complies with all the necessary service of the necessary documentation, as I mentioned, the environment, the EPC, the how to rent guide, and so on, the prescribed information. If those are that's part of the box work. If the claim, accelerated possession claim, will attach or requires the landlord or the claimant to set out, have you served this document, have you served that document?
Yes, it's box work in both senses, in that it's done out of court and it really is a question of ticking boxes.
It is ticking boxes, it literally is. But if the landlord, for example, ticks a box and says, I did serve the EPC, or the gas safety certificate, but the gas safety certificate is defective and therefore cannot be treated as a gas safety certificate because it breaches the regulations, then there is a defence. And that's when the matter, albeit listed for or indeed referred to for an open court hearing for 5 minutes, the issue can be raised and then adjourned off with directions for determination. That's the protection that's given to the tenant. But this process of ascertaining the rental, or the monetary value of the payment in kind is a matter which is available, which the court are used to dealing with and can be carried out to determine whether or not the Act is engaged. Now, my submission, my Lord, Parliament, having deregulated the private rented sector in the 88 Act, wouldn't have left the Act open for the coach and horses to be driven through it, namely to say, well, rent has to be payment of money, a pecuniary payment, for there to be any form of protection, absent which then you're reliant upon the Protection from Eviction Act and the service and notice to quit. It is my submission. It is the narrow construction proposed by the respondents is one that enables the coach and horses to be driven through the protection that has been afforded, albeit more limited protection, but still protection in itself, to the tenant under the 88 Act. My Lord, my learned friend referred to the case of Bostock and Bryant in the bundle, and my Lord, if I could just take your lordships to that. It's in tab 9, page 163 of the agreed bundle, and it's important to note the facts of that case, and that was that the defendant, who claimed to have a tenancy, was occupying under an arrangement with the then what subsequently deceased tenant, and it was agreed that they occupy the house along with the tenant and paid only the gas and electric bills in respect of the house. And when the defendant's husband died, the tenant said, well, not to worry about her future, she could remain in occupation. And it was only on his death that the landlord sought to recover possession. And the judge rejected that there had been, as having heard the evidence, that there was any payment of rent, albeit it had been claimed to have been paid £5 a week. That was rejected. So, but possession was refused on the basis that the payment of the bill, gas and electric bill, amounted to payment of the rent. So that's the bit. Those are the facts. There was no. When one compares the facts of that case to this case, there was an express agreement. There was no agreement. There was express provision in respect of what is the rent to be paid, which accords with the common law, namely payment in services in lieu of actual pecuniary payment. And in this case, and in the case of Bostock, no payment of rent at all. No services were provided at all, and it was a simple payment of gas and electric, which fluctuated. So it's not a case where at some points, due to the payment, as Lord Justice Stuart Smith mentioned, it would fluctuate, so that it could argue on the tenant's or the defendant's argument that it goes in and out of protection. In this case, the question is, well, 2 days minimum of services provided over the period of time is quantifiable, and indeed is quantifiable by reference not only to particular circumstances and what information is available at the date of the hearing, but also how the landlord has dealt with the receipt of the services in terms of his own accounts. So the facts are very different, and indeed reference to the citation that's made in reliance upon Barnes and Barrett, clearly that the facts are very different and are to be distinguished. Finally, two final points. My learned friend, in terms of Renters' Rights Act 2025, the only point I would add is that, for example, at section 56, there's a requirement to state the rent when it comes into force and what rent is payable. It applies, these provisions apply only to assured tenancies. So one goes through the process, first of all, to determine whether it's within the exclusions, and if it is, then that doesn't apply. But if it does, then there is the requirement to specify and to state what is the rent, and what that is the rent that is payable. The rent that is payable under the letting, which would seem to in my submission, it's still open to say, even though a landlord could put forward, well, the rent payable is X, but you're going to do services 1, 2, and 3, which equates to that. Therefore, that is the rent that's payable. And there's nothing to prevent a landlord reaching that or putting that forward in my submission as a proposition for a tenant who may say, well, I have those skills. It gives me the protection in terms of I have a tenancy, but I don't have to pay for the occupation of the accommodation. So in my submission, it is still, it cannot be Parliament's intention that a landlord can easily sidestep what protection there is and indeed going to be afforded by refusing to agree, or indeed failing to specify and value the services that are provided as rent, so that there is a tenancy but it's unprotected and therefore terminable by notice to quit. That, in my submission, defeats the purpose of the legislation to provide security of tenure. And importantly, when one deals in situations like this, one has to recognise, in my submission, that tenants are in such circumstances are would be vulnerable to agreeing to carry out services for no income, to occupy a home which they and have no income, to be able to then better themselves, to then move on to provide security by securing a accommodation for which they can afford. They're stuck effectively in that arrangement. And in my submission, that gives rise to the question of modern day slavery in terms of ensuring that occupiers are able to be protected, their rights to occupy are protected by the courts to ensure that they don't find themselves out of protection and no means to be able to move on other than to find themselves homeless and having to present to the local authority. In my submission, my lord, that cannot be the Parliament's intention, that a coach and horses can be driven through the protection, which in my submission, that's what this narrow construction, or even following the words of Lord Justice Sachs, that there be an agreement of the monetary value of the services provided. A landlord could simply refuse, if one adopts Lord Justice Sachs' approach in Barrows, a landlord can refuse to provide a valuation, in which case the tenant is stuck, and that cannot be, in my submission, the right course, because a tenant with accommodation over their head, with a roof over their head, will not easily give that up to become street homeless just because they don't want to do the work. They will be caught in this cycle, and by extending the definition, or by reading into the Housing Act 88, the common law definition of what is rent, and my submission provides the protection. Landlord is not placed in any worse position. He just has to prove that he is entitled to possession based on a true reading of the agreement and the valuation which he puts to it, which the court either accepts or rejects. And if they accept, well, then that be the position. But the tenant would clearly be entitled to make submissions as to why the tenancy is protected under the 88 Act. So accordingly, my lord, my lords, my lady, the approach of the court, namely that rent is monetary payment, is in my submission is unlawful, unless I can assist.
No. Thank you, Mr. Colville. So thank you very much, Mr. Colville, Mr. Doyle, for your respective submissions. We will be reserving our judgments, and they will be provided to you in draft for the usual, as you know, limited purposes. And it's very important, as you will also know, that you adhere to those limited purposes, and they are provided to you so you can identify typographical errors. And we would assume that you will be able to agree a draft order in the light of those judgments, but if not, we will deal with any outstanding matters on paper.
Thank you
So
very much.
thank you very much.
My lord,
Yes.
we'd had some discussion earlier of, would you like us to obtain the white paper for you or anything else?
Not really. I mean, if you can find it and look at it and see if there's anything in it of relevance, then yes. I don't know how long it is, but I don't think just send it willy-nilly. But I think it would be helpful if you could find it, look at it, and see whether it has anything of relevance.
We can
Yeah.
If you could identify any passages in it which either of you thinks is relevant, that would also be helpful.
Yeah. Okay. Thank you very much.
Thank you very much.
You guys are able